Good morning, Europe, and good afternoon, those in Asia. Welcome to our webinar entitled The Impact of the Pandemic on Brand Protection and IP in China and Southeast Asia. This webinar is brought to you by the China and Southeast Asia IPR SME Helpdesk. My name is Nora, and I will be today's webinar moderator. And joining me shortly will be Simon Cheetham, our external expert for both China and Southeast Asia IPR SME Helpdesk. But before we hear from Simon, let's make sure that we all have a good understanding how this webinar platform works. So during the webinar, we are looking forward to a lively discussion. So please get in touch with us by typing in questions through the question box, and we will be addressing your question at the end of the webinar during the Q&A session. This webinar will be an interactive session, so please also participate in the poll questions that we will be launching throughout the presentation. And as a last note, keep in mind that today's webinar is recorded, so we will also upload the recording to our website a few days after the webinar, so you will be also able to access the recording. And before we dive in the presentation, let's have a quick look at today's webinar agenda. So first, I will give you a quick overview about the IPR Helpdesk services. Then Simon will update you on the impact of the pandemics and brand protection and IP in China and Southeast Asia. And we will close the session with hopefully an interactive Q&A session. So the International IPR SME Helpdesk are an initiative of the European Commission to support European SMEs to protect and enforce their intellectual property rights in relation to China and Southeast Asia. And I also would like to tell you that we have two other sister projects. One is for Latin America and another one is on Europe. So if you have any IP questions related to any of these regions, please get in touch with the Helpdesk and we will be able to give you more information. And let's have a quick look all the services that we can give you, just very briefly. So through our inquiry helpline, you can get in touch with us to get confidential IP advice related to your business. This can be via email, phone, Skype. We also have a wide range of publications available on our website. This is valid for both China and Southeast Asia Helpdesk. So we have country fact sheets and various industry-specific guides or any other IP-related publications. We also organize on-site trainings across Europe and Southeast Asia and China, although we took a little break during the pandemic and we shifted all our activities to online. So check out our events calendar because we have many online sessions these days. And at last but not least, we also have some interactive learning tools such as e-learning modules that you can also check on our website and participate in our quiz session and be sure that you learn your IP lesson. And now, without any further ado, I would like to pass the floor to Simon, who is our external expert for the Southeast Asia Helpdesk, team leader for the China IPR SME Helpdesk. Simon has lived more than 17 years in China and Southeast Asia and has over 30 years of experience related to IPR enforcement, and he's a managing director of Erinyes International, and he's monitoring the IP system of both regions. So let's now connect with Simon. Can you hear me, Simon?
Hello, Nora. Yes, I can hear you. Thank you.
Yeah, thank you. And yes, so please share your screen. And while you are sharing your screen, I would like to tell our participants that we received a very interesting question before the webinar, which was about what do you see being the main changes with the IP system in China and Southeast Asia that will be after COVID-19 when the pandemic is over. So I would like Simon to comment on this question, and later on this webinar will give some further answer to our participants. I can see your screen, Simon.
Okay, very good. Well, thank you. Thank you very much, Nora. And this is an interesting question. It actually speaks to the theme of the presentation. And I think one of the perhaps clear changes that we may see with respect to IP as a result of the pandemic is the increase in business activity online, as opposed to what has historically been a lot of physical activity, and that in itself will need a shift in strategy and thinking in terms of protecting intellectual property as we go forward. And these are issues I hope to elaborate on as we go through today's presentation. So perhaps I'll continue into the presentation, and then hopefully that'll address that question and perhaps answer a few other questions that people may have as we go onwards. This is the agenda for the presentation I'm going to give. I would like to touch upon sort of 6 areas. First is just some background information on Southeast Asia and China, and then to delve into the lead up to the pandemic. It's been an interesting time, both in China and Southeast Asia, in terms of changes that have already been underway. And so I'd like to bring that information to you. And then look at the shutdown and the measures that are now in place to get things restarted from an intellectual property perspective. And then take a look at some of the new trends that have already come out of the era of the pandemic, if you like, and to give you some direct feedback about what it's like on the ground. In my own business, as Nora mentioned, I work quite a lot on brand enforcement issues. And so I'd like to just give you a little bit of feedback on actual brand enforcement now that the pandemic is beginning to ease. And finally, just to offer a couple of takeaway messages. But before talking about the lead up to the pandemic and setting the scene for Asia and China, I wanted to explain the basis for making some of the observations that I will comment on. And in part, this is based on personal hands-on experience working on brand enforcement in Southeast Asia and China. And that includes meeting with law enforcement and other IP practitioners. But it is also based on inquiries we've received at the Helpdesks, which are funded by the European Commission. So the next couple of slides give a general indication of the type of IP issues that businesses are seeking help on. These charts are based on inquiries to the Helpdesks in 2019. And what they do is they show the type of right that has been the subject of the inquiries that the Helpdesks have received. In the case of Southeast Asia, the biggest segment, if you will, has been on trademarks. Nearly around 60% of all inquiries have had something to do with trademark issues. But invention patents and general intellectual property strategy questions have also featured highly. Trade secrets has been a small but nevertheless significant portion of the inquiries received. On top of those inquiries, of course, we have input from a panel of experts who work and collaborate with the Helpdesk and twice each year provide new information on changes to legislation and other trends and issues that they've seen around the region. And if you look at China, there's a sort of overall similarity to the pie chart in that trademarks again form the biggest number of inquiries to the Helpdesks. But general IP strategy forms the next biggest section of inquiries received over the last 12 months. And copyright and patent issues also feature quite highly in China. So these are some of the sources of information which help us make comments on the topic that we're talking about today. So if I may, just to set the scene, if you look at Southeast Asia and China, one thing becomes clear. It is difficult to look at any one market in isolation. I think it's fair to say that goods and information flow quickly from country to country. In Southeast Asia, there is the ASEAN Free Trade Area, known as AFTA, which is a trade bloc agreement by the Association of Southeast Nations, Southeast Asian nations, I should say, supporting local trade and manufacturing in all these countries. It actually stands as one of the largest and most important free trade areas in the world. So if you sell your brand of products or services in one country, you have to be prepared in case competitors jump in and register something similar next door. China, well, China is the largest exporter in the world. China's highest value export products in descending order are mobile computing devices like tablets and laptop computers, cell phones, smartphones, computer processors and controllers, and liquid display panels. There's a free trade agreement between China and the ASEAN nations, which came into effect in January in 2010. And that created the world's third largest free trade area in terms of GDP. But China's also established free trade agreements with many other countries, including Australia, Korea, Pakistan, New Zealand, Singapore. And there are more free trade agreements under negotiation with the Gulf Cooperation Council, with Japan, Norway, and Sri Lanka. So this is the area that we're talking about, a dynamic and populous area with strongly growing economies. Before we go into the specific details of what has been changing in the IP sector in the lead up to the pandemic, we would like to just have a brief poll question to everybody. And it might be helpful to us to know if you could just let us know whether you already do business in either Southeast Asia or China. You'll see that there are 4 options to answer, either yes, you do business in Southeast Asia, or yes in China, or yes to both, or not yet. So Nora, perhaps I can hand over to you to collate details of the poll, and it would be interesting to see the feedback we receive.
Yes, sure. Thank you, Simon. So we have launched the poll question now, and waiting a few seconds for the participants to select the correct answer that's valid for their situation, and then we will discuss the result, which will also give us a little bit of understanding on your background, and that can also help to navigate the webinar later on. So let's wait a few more seconds, and then we will launch the result. Okay, we are not receiving more votes, so let's see what we have received so far. We can launch the result. So, okay, interesting. 25% is saying yes, they do already business in Southeast Asia. 8% yes in China. 17% in both China and Southeast Asia, and 50% not yet. So half of our participants are new to these 2 regions. What do you think, Simon? Can you comment on the result?
Oh, thank you very much, Nora. This is interesting. Yes, I mean, it's first of all, it's interesting to see a significant proportion that do businesses in both regions. And there is this interconnectedness in business and trade, which suggests that's likely to be the case. But equally, that 50% have not yet started business in either region is very encouraging, because one of the key objectives for the help desk is to try and reach businesses in a timely way, ideally before they start doing business in these regions, to equip everybody with the right knowledge and awareness in order to succeed from an IP perspective in these areas. So that's very encouraging that so many people who have yet to start business in these regions are are attending this this webinar. So interesting result. Maybe now let's take a look at what was going on in Southeast Asia and China in the months before the pandemic. This has actually been a time of significant change, and the overall trend is one of progress. This slide highlights a number of examples. There are really too many to go through all of them. So we've just picked an example from each country. But if you look at Brunei, for example, a relatively small country, a reorganization of the intellectual property offices there took place in 2019, so that the IPO, the Intellectual Property Office, is now under the umbrella of the Attorney General's chambers. And what this has done is it's brought all IP matters under one body, whereas previously only copyright issues were dealt with by the Attorney General's chambers. This is an encouraging step. Incidentally, Brunei also joined the ASEAN trademark view and design view systems in 2019. These are two free of charge online platforms to access information on applications and registrations of trademarks and designs in participating ASEAN countries. So for Brunei, the main recommendation for SMEs is always register IP in Brunei to be able to effectively protect rights and where you need to enforce them. In Cambodia, in the past 3 years, Cambodia has enacted a number of new laws and implemented new policies, despite it being a member of the World Trade Organization's agreement on trade-related aspects of intellectual property rights, which is TRIPS. Cambodia is still listed as a least developed country. So it has basically until the 1st of July 2021 to comply with the TRIPS agreement, with some limited exceptions, and to comply with the key criteria of the Berne Convention, which is the international agreement dealing with the protection of literary and artistic works and other rights of their authors. This is actually of special importance for the protection of copyright. There's been significant improvement in the administrative enforcement of trademarks through the Counterfeit Committee of Cambodia, CCCC. Along with the economic police and other authorities, they are in charge of enforcing intellectual property rights. So we've seen a number of quite large-scale raids and seizures of literally tons of counterfeit trademark products, including medicines, in the last 12 months. We've also seen the validation of the European Patents Agreement, which came into force on the 1st of March in 2018, making Cambodia the first Asian country to validate European patents. So European patents granted by the European Patent Office and validated in Cambodia will have the same legal protection as a corresponding Cambodian patent, and will be subject to the Cambodian patent law. In fact, the European Patent Office experts are involved in training staff at the Ministry of Industry and Handicraft to help increase understanding of patent information. In Laos, the decision on geographical indications was published late in 2019, and this gives details on the registration process for either a local, domestic, or a foreign entity to register its geographical indications. Laos is endeavouring to formalise new geographical indications in the relatively short term, after it had really the birth of its first label regarding a type of sticky rice from a province in the northern part of the country. It's also perhaps relevant for businesses to know that a digital platform will be created and will publish and notify third parties of the submission of a new trademark application, and that is expected to be up and working in the near future. In Malaysia, we've seen the recent introduction of the Trademark Act 2019, which repeals and replaces the older Trademark Act, which dated from 1976. And also in December 2019, Malaysia became the 106th member of the Madrid Protocol. So that the new act will actually have an enormous impact on the Malaysian IP system. Just to give a couple of examples, under the new act, a single application for a trademark in one language can be made, and it can lead to the registration in a total of 122 countries through the Madrid Protocol. Also, multi-class applications are now available to cover goods and services in more than one international class. And there's expansion on the scope of trademark infringement too. So Malaysia has seen some encouraging developments. In Myanmar, the parliament there is in the process of finalising 4 pieces of legislation on protection of intellectual property rights. The trademark system in the country is in the process of changing from a first to use to a first to file system. The new law has been approved, but the implementing regulations are not yet in place. In the Philippines, there have been no substantial changes to intellectual property law, but in December 2019, the Intellectual Property Office of the Philippines published their national IP strategy, which outlined the framework and policy priorities of their office. There are 1 or 2 laws relating to intellectual property, such as the Personal Property Security Act, which gives the framework for SMEs to access least cost credit and expressly includes intellectual property as a collateral option. Before this, only physical or real property was accepted as collateral. Incidentally, in the Philippines, there are special intellectual property courts and specialized judges who have at least a solid understanding of intellectual property related issues. But be aware that actions filed before the courts can still take time to be decided because of postponements or unavailability of judges, and this has only been exacerbated by the current pandemic. In Singapore, well, Singapore has one of the most efficient and comprehensive intellectual property protection regimes in Asia. It's moving towards its goal of becoming a global intellectual property hub in terms of IP transactions and management. The procedures there are generally swifter than those in neighboring countries. It's got a transparent legal system and it's got efficient courts. Also, the EU Singapore Free Trade Agreement will enter into force in November 2021. In Thailand, in recent years, Thailand has substantially improved both the protection and the enforcement of its intellectual property regime. The most recent development concerns the latest amendment of the Copyright Act. And this was amended in accordance with the Marrakesh Treaty to basically to facilitate access to published works for people who are blind or visually impaired or otherwise print disabled. And in Vietnam, Vietnam is going through some pretty important changes regarding its IP legislation. Back in June 2019, the European Union and Vietnam signed the EU-Vietnam Free Trade Agreement. And this was approved by the EU Parliament in February 2020. And this will require the Vietnamese intellectual property law to be amended. Also, the Hague Agreement took effect in Vietnam in December 2019, which allowed the Hague system users to designate Vietnam as an international design location. If we turn to China, there have also been big changes in China, really stemming from 2018 when there was a major restructuring of their IP registration, management and enforcement governing bodies. And this was announced during China's Two Sessions meeting in March 2018. Essentially what it means is that the State Intellectual Property Office and the China Trademark Office have merged together under the China National Intellectual Property Administration. So these two entities originally were quite separate under separate ministries, and that tended to give a slightly different perspective from each. SIPO tended to deal more with foreign issues, whereas the China Trademark Office tended to be more inwardly focused. And we now hope that, and the signs are reasonably good, that by merging the two entities, there is a more balanced outlook. Taking a look at some of the other changes, the China National Intellectual Property Administration revised the Chinese patent examination guidelines, which have been revised several times before, but they've produced another set of amendments, including on the examination of inventiveness, interviews with the examiner, and permitting some delayed examinations. They published some new amendments on examination guidelines for computer-related inventions in February this year, which also have an impact on AI-intensive technologies. And the new guidelines state that for a technical solution, that the AI technology must have a technical effect performed by the AI computer program in order to comply with the non-obviousness patentability requirement. But also of interest is the January 15, 2020 US-China Phase 1 trade agreement, the date it was signed. This includes some notable agreements on patents, mostly related to pharmaceutical sector, but which might have an effect on all patent applications if China modifies its patent regulations accordingly. But also on trade secrets, the protection of trade secrets has been strengthened through the amendment of two major laws. The first is the Foreign Investment Law, which came into effect in January this year. And Article 23 of that law stipulates that the administrative organs and their functionaries have to keep confidential the trade secrets of foreign funded enterprise they have learnt about in the course of performing their duties, and requires them not to divulge or illegally provide those secrets to others. So this is actually a particularly useful a clause for those foreign companies that have to reveal some trade secrets in order to obtain approval of an authority to import or export or sell their products. But it remains to be seen how this will actually be implemented. There are still, I have to say, there are still many administrative proceedings related to business transactions, like product imports, technology transfers in joint ventures, and so forth, where foreign parties are required to provide know-how and trade secrets in order to obtain approvals. And these regulations tend to be hidden in many sectorial laws, and administrative discretion just adds to the risk of foreign IP being mishandled. So that's something to be cautious about. But the second major law of interest is the Anti-Unfair Competition Law. And this introduced two major changes with regard to trade secrets. One is that the transfer of the burden of proof, requiring a suspected infringer to prove that the trade secret claimed by a right holder does not fall under the category of trade secrets in this law. So the revised law reduces the burden of proof for the rights holder of trade secrets and makes it easier to get legal relief. And this is actually reinforced with the second amendment that increases the maximum compensation in the case of a trade secret infringement to 5 million renminbi instead of 3 million renminbi, so nearly doubling the amount. 5 million renminbi is around 640,000 euros. Right now, there are not enough trade secret infringement court cases that we're aware of to analyze the application of these new laws. But some people have noted that judges tend to make different decisions in different locations, with Jiangsu and Shanghai demonstrating more experience and consistency when hearing trade secret cases. And just a quick mention on the US-China Phase 1 agreement on geographical indications. And this stipulates that China must assure full transparency and procedural fairness with respect to the protection of geographical indications, including safeguards for generic terms and respect for prior trademark rights. And they have to provide clear procedures to allow for opposition and cancellation. And finally, just to take a look at the issues relating to trademarks in China. In November 2019, the amended trademark law came into force. And overall, the aim of the amendments was to tackle bad faith trademark registrations and to increase the punishment for trademark infringements. There were a couple of really significant changes. One was Article 4, which stated that malicious trademark registration without an intention to use should be rejected. Traditionally, due to the first to file system, a large number of trademark squatters maliciously registered well-known trademarks or hoarded trademarks for profiteering. There's a couple of other articles, 33 and 44, which allow brand owners and other interested parties to challenge malicious trademark registrations in the opposition and invalidation contexts. So on the one hand, there's a possibility for companies, including foreign companies, to bring bad faith registrations to the attention of the CNIPA, and that's basically a positive improvement. But as a result of these changes, foreign brands that have not yet acquired a certain reputation in China can now invalidate or oppose hostile marks based on the grounds of abnormal filing. So those are good points. But on the other hand, allowing more interventions by companies in the registration process can become an obstacle for certain brands. And this is, we feel, particularly in relation to geographical indications. There are several other articles too, but without going too deeply, I just mentioned the anti-unfair competition law again, which introduced amendments to protect brands. Article 6 extends confusing acts to unauthorized use of domain names, website names or websites, and that in turn enables the trademark owner to stop the infringement and claim damages based on unfair competition, and not only based on trademark claims. But despite these recent improvements, trademark squatting remains a huge problem in China. And in practice, at least for now, it's unlikely that the CNIPA will be able to stop all the illicit filings during examination proceedings. So while rights holders now have more grounds to recover the stolen marks, it's still necessary to proactively oppose and invalidate bad faith registrations. And I should also say that with the evolving legislation, it's been notable that infringers have become more sophisticated. When a product or brand is popular, competitors will first look to register the trademarks, and when they start facing administrative raids, they will start making lookalikes, using similar but perhaps not the same trademarks and or trade dress. And they'll establish companies with trade names similar to the brand so as to confuse consumers. Often they will also use sort of shell companies for this activity to avoid any legal liabilities. So these are some of the more significant changes. As you see, there's been a lot in the lead up to the pandemic. Before we start looking at the pandemic era itself, we're going to have another poll question, and we thought it'd be interesting to ask whether the pandemic has already changed anybody's IP strategy for Southeast Asia or China. There are just 3 options to answer, and it would be fantastic if you could let us know your answers for each of these. So A is yes, B is no, and C is that your strategy hasn't yet changed, but it may do. So again, I'll hand back to Nora to see if we can collate the results from this poll and see what information that gives us.
Thank you, Simon. So we are waiting for the participants' vote. So I encourage everyone. There is no good or bad answer here. So please participate in the voting, and then we can discuss it together. Okay, I think we can share the result. Majority of the participants have expressed their opinion. So 18% said yes, the pandemic indeed changed their IP strategy for Southeast Asia, China. 9% said no, they did not implemented any changes, and 73% not yet, but may do. So 73, sorry, the last option. So actually we have a clear majority here, which is probably somehow understandable that everything is very uncertain now. So Simon, please comment.
Yeah, thank you, Nora. Absolutely, and I think that result, of course, is also partly driven by the 50% of attendees who are not yet doing business in Southeast Asia or China. So and obviously won't necessarily have had an opportunity to change their strategy in relation to these regions. So that is almost an expected outcome in a way. But it's interesting to see that of those, a bigger proportion of those have already changed some aspect of the IP strategy, and it would be interesting to see the reasons for that and whether they coincide with some of the reasons that we'll be discussing now. So if we perhaps move on now, we've discussed the changes being made to intellectual property laws in Southeast Asia and China, which is leading to, I think overall you can say it's leading to a steady upgrading of the intellectual property rights regimes. But there are two main factors which seem to be driving this change, and they are accession to trade agreements, particularly the World Trade Agreement, TRIPS, as countries look to enhance growth through trade, but also a growing recognition that innovation is key to increasing value. And another key component of growth is, of course, innovation. Innovation can only flourish under an effective IPR regime. And you can find examples in most countries. But I think I'm going to use China as just a bit of a case study to demonstrate what I mean. Back in 2006, China set a goal to establish an innovative country, followed by a national IP strategy in 2008. And that strategy is leading the whole country, both at a central level and a local level, to put much more emphasis on intellectual property. Intellectual property is now an important part of China's national development. And this was reflected in China's report. This was the National Medium and Long-Term Plan for the Development of Science and Technology, a report covering the period up to and including 2020. And the focus in that report was on employing China's fast-growing domestic market and powerful regulatory regime to decrease reliance on foreign technology and develop indigenous technologies to enable China to deal with its massive environmental infrastructure and social problems, and to enhance its economy and national security. Now, the interesting thing is that indigenous innovation to China is seen as enhancing original innovation through co-innovation and re-innovation based on the assimilation of imported technologies. In fact, that plan, the National Medium and Long-Term Plan, warns against blindly importing foreign technology, without plans to transfer it into Chinese technology. And the report actually states one should be clearly aware that the importation of technologies without emphasizing the assimilation, absorption, and re-innovation is bound to weaken the nation's indigenous research and development capacity. And so what does all that mean? Well, let me give you an example. In the 1980s, China established a series of research projects for the development of grid connecting small wind turbines. But these early prototypes were not commercialized as China's research and development cycle was too slow to keep up as the market rapidly advanced into larger turbines. In 2004, foreign wind turbines had a 75% market share in China. But in the subsequent years, China was directed by its government increased investment in wind energy projects. Dozens of companies sprang up, but to upgrade domestic capabilities, the foreign involvement in the manufacturing of wind turbines over a certain size, 1.5 megawatts, was restricted to joint ventures or partnership. And so by 2009, the three largest domestic companies, Sinovel, Goldwind, and Dongfang, alone had 60% of the market, and the foreign share had dropped down to 14%. The Chinese government in late 2009 removed the 70% content requirement after complaints from foreign governments, but it was only a symbolic move. Now they have nurtured and developed the domestic manufacturing capability. Their domestic players can now independently manufacture, and they own the market for 1.5 megawatt wind turbines. And Chinese wind investment has continued to rise. It rose 4% to just under $18 billion in the first half of 2018. And currently there's the Made in China 2025 strategy, which amongst other things promotes specialization in high-end shipbuilding and offshore engineering equipment and manufacturing. So even before the pandemic, I think we can all agree that the trend has been towards more online sales and more business activities. But at the China Helpdesk, we've seen a sharp increase in the awareness of SMEs to online counterfeit sales in China. And I know that the similar effects have been seen in Southeast Asia. And so for this reason, many businesses are eager to strengthen their trademark portfolios and file applications for trademarks, as well as other intellectual property rights such as design patents. And I'm not focusing solely on China here. The Thai Computer Crime Act was recently amended to solve several issues, including online IP infringement through new enforcement measures. Today, intellectual property owners have two options available from two separate provisions of the Copyright Act and the Computer Crime Act that both deal with infringement issues. The first option is the copyright owner has to file a motion with the court requesting an injunction to stop the infringing material. Or the second option is to use the Computer Crime Act to block websites, and the IP owner may provide the URL address of an infringing website to the Ministry of Digital Economy and Society, so they can file a motion with the court requesting that the website be blocked or its content deleted. Cyber theft of trade secrets has attracted more interest in the lead up to the pandemic. Perhaps most of us think of cyber theft in terms of financial fraud or identity theft. But trade secrets, technology, new inventions, new innovations, I should say, and proprietary information are also actively targeted and vulnerable. The implied resources involved sometimes suggest state-level actors, but irrespective of who's doing it, being aware of the danger and taking steps to prevent cyber theft is something we can all do. Technology transfer issues in some markets, as shown in the wind turbine example, there are often issues which make it more challenging for the foreign entity to succeed in markets, and there are things to be aware of and to be researched. And bad faith brand registrations, which is a danger to businesses not only in China but throughout Southeast Asia. It's always a danger in a first to file jurisdiction. So these are issues to be aware of. So looking at the shutdown measures and what's actually happening now in Southeast Asia and China, I think we all know that the COVID-19 virus meant a lockdown affecting all countries in Southeast Asia and China to reduce the spread of the virus. The quarantines obviously affected not only private companies, but also many government offices, and it's caused a series of new and unexpected issues, ranging from the economic and financial difficulties that companies continue to face, to the new challenges posed by large-scale work from home working arrangements that necessitate new ways of protecting intellectual property, particularly for trade secrets protection. The coronavirus outbreak also presented challenges such as the suspension of the intellectual property registration procedures in national IP offices. And I'm glad to say that there has been some move towards resumption of registration procedures around Southeast Asia. So Brunei's Intellectual Property Office has updated its services operating hours, but it does actually physically open Mondays to Thursdays and on Saturdays, so some access is possible. Cambodia has expanded its e-filing of trademarks in response to the COVID-19. And the Department of Intellectual Property Rights of Cambodia has implemented new functions in its e-filing system to allow for online submission of most post-registration matters. In Indonesia, the DGIP, the Directorate General of Intellectual Property, held a virtual morning meeting through a video conference with all its employees on the 26th of May to announce a shifted schedule for employees working in the office, that they will provide facilities for their staff to work from home to support their work. So again, we would expect to see some resumption in processes in Indonesia too. In Laos, on the 11th of May 2020, the National Task Force Committee for COVID-19 issued recommendations to generally ease the required prevention measures. So there's been a new list of conditions and measures that have to be adopted before a company's operations will be allowed to resume in full, but there is movement towards that. And in Malaysia, the Malaysian Intellectual Property Offices announced limited opening of their customer service counter at its headquarters and branches from the 9th of June 2020. In Myanmar, the President's Office has issued a letter containing measures to mitigate the impact of the pandemic on government offices. Essentially, government offices and departments have reduced their staff by 50%, which we think is on a rotating basis. In the Philippines, the Intellectual Property Office there has resumed limited regular operations at its main office from the end of May. And some cashiering operations too at their main office. My own company is actually representing a Philippine corporation on some brand enforcement matters, and has just in the past week been able to issue notarized powers of attorney, but was unable to have those legalized at the Chinese embassy in Manila, as the embassy had not yet reopened. In Singapore, the Singaporean IP office is remaining closed until further notice, but its online portal and mobile apps are still available. And like most jurisdictions, IP owners that need more time beyond existing deadlines can do so by filing for a request for an extension of time because of circumstances related to the pandemic. That's similarly the case for Thailand, where the Thai IP office has allowed requests for extensions of time. And in Vietnam, following a new notice on the loosening of social distancing measures. The IP Vietnam office has resumed receiving applications directly in Hanoi and in its branch offices in Ho Chi Minh and Da Nang, and online applications and applications via post are still being accepted as well. Incidentally, the Vietnamese government has provided a temporary 50% discount until the 31st of December 2020 on certain industrial property fees at the Intellectual Property Office of Vietnam, such as fees for filing applications, extension of time limits, issuing registration certificates, and so forth. So they are doing their bit to try and encourage businesses and support them. Perhaps I should also mention that the World Intellectual Property Organization, like most other organizations, is operating with staff working remotely rather than operating from its office premises. Turning to China, the Chinese government has implemented a program called 10 Measures to support the resumption of work and production. And there are really 5 main points to take into consideration regarding intellectual property within those 10 measures. And that's the 5 points listed on the slide. So, for example, in order to immediately address urgent issues, the CNIPA has given priority to trademark and patent registrations to companies that have shifted their production to emergency supplies, such as masks and protective suits, or producing drugs for epidemic prevention and control. Also, help is being given to every patent or trademark that might be useful in the fight against the virus. Also, the CNIPA is opening a fast-track system to streamline the application and registrations of patents and trademarks involved in new business projects for those companies that are in the process of resuming work and production. There is some complementary financial support provided to different companies in different ways. And in all these policies adopted by the CNIPA, there's no mention whether only Chinese businesses can benefit. There's no precedent for financial assistance being given to foreign companies, but presumably a foreign business with offices in China that's in the process of resuming normal work might be able to request to be included in one of the financial benefit schemes. Like most other countries, intellectual property rights that have been affected by the closure of the CNIPA office can retain their status by making a written request to restore their right. So in some countries, such as China, we are seeing a trend for voluntary copyright registrations obtained for imitations of trademarks. And these products are often sold on e-commerce platforms, and the brand owner is forced to go to court to have the copyright registration revoked. And this is a trend that we think may spread to other countries. Since copyright is voluntarily registered, it's relatively easy to get registrations imitating registered trademarks of other brands. And with these copyright registrations, infringers can promote and sell their products on quite a large scale using e-commerce platforms, and also using international trading events like the Canton Trade Fair, for example. They can typically display their copyright registration certificates on their website and persuade the public that they have the right to use those marks, which is obviously harmful to the brand owner. And we're seeing the impact of this where brand owners have tried to have sites advertising infringed products taken down, or where they've asked criminal or administrative enforcement authorities to take action just to be met by a copyright registration certificate produced by the infringer. So it's important to bear in mind that in some jurisdictions it's difficult to remove a copyright registration, even with proof of prior publication of the artwork. a court decision is typically mandatory. So the takeaway suggestion here is to carefully consider copyright as a means to reinforce ownership of your distinctive logos or marks. And where there's an option to register copyright, try and do so, even if it means registering your trademarks as copyright too. Another trend that's been identified of some concern is cyber security. The US-China Phase 1 trade agreement mentions specifically electronic intrusion as one of the examples of acts that constitute trade secret misappropriation. And this leads to the implications of the cyber security law in China, effective from June 2017. The legal framework of this law is not very detailed, and its provisions are dispersed in various laws and regulations. But to implement it, multiple implementation regulations have been released, and further regulations are still pending. They are expected to clarify the scope. For the moment, though, the cross-border data exchange is the topic that is more relevant in trade secret protection for two specific obligations businesses must comply with. The cybersecurity law imposes an obligation to store personal information and important data in servers located in China. And this is data that, if leaked, may directly affect China's national security, economic security, social stability, or public health and security. So basically, every business that collects information in China must store it in a Chinese server, which is located within the territory of China. And that means that the Chinese office of a foreign business can't use the server it might have in its headquarters, but must either hire a Chinese server or create its own in China. And also, every time information goes into or from the server located in China to one abroad, it will be considered as a cross-border transfer. So as a result, this company should understand that this internal sharing of information between branch offices is going to be considered by the cybersecurity law as cross-border information, and therefore must comply with the second main provision, and that is that a security assessment is required by the Chinese government. Also, I should mention, with regards to cybersecurity, the protection and the protection of trade secrets, the anti-unfair competition law classifies hacking as a means of trade secret misappropriation. And in the event that a trade secret owner is able to provide some sort of simple evidence of trade secret theft by hacking, they can have the option to take legal action. I'm not aware of any precedents so far to give you any specific case examples. So those are a couple of trend areas I wanted specifically to mention. I appreciate we're running over a bit now, so I'm just briefly going to mention what it's like on the ground. The situation in some jurisdictions is certainly getting back to normal. These pictures were taken in the middle of May and late May, two separate occasions in China, where some enforcement actions were undertaken by the authorities there. So in China and in some other Southeast Asian countries, the authorities are receiving complaints and are undertaking raids. And obviously this is not an easy thing to do in hot and humid conditions while wearing face masks. But other events to do with enforcement that may be of assistance to you, such as training events with law enforcement authorities, have not yet resumed. You can have small-scale meetings with law enforcement in some jurisdictions, and that's certainly possible in China. And I'll just add one other thing, and that is this week we are undertaking an enforcement action on the first case for us of its kind, and that is against a manufacturer of scarves, which are used as face coverings. And as we suspected would be the case, are now being offered by infringers under different brands to try and maximize their profits. So we're drawing to the end of the presentation, and questions arises whether it's time to diversify. because of the pandemic. There's no doubt that the pandemic has impacted supplies of products, and it's led many to consider having different suppliers and not just sourcing from different companies, but also sourcing from different countries. The point is that there will always be a need to ensure that intellectual property is registered in the locations products are sourced from. So it's important to be aware that IP regimes may be different, and do also consider local language marks, as a product may find its way into local markets where the brand recognition is important for your company or your products. Trying to anticipate future developments is something all businesses should obviously try and do. Choosing local partners in new places to do business does not mean you should not follow best practice and take steps such as doing due diligence on local partners you may choose to work with. And in that connection, I just wanted to offer one tip, and that is, and this is possible in China and in other jurisdictions, if you are looking to work with a new supplier, a new business partner, one of the checks you can do is to look at what intellectual property they have registered in that market. If you find that your prospective supplier or partner has registered many rights which you recognize to stem from perhaps the European Union or elsewhere, then that should be a red flag. It's well worth conducting these searches on these partners, as that can be a useful indicator for you. So how do you get your intellectual property portfolio ready? Well, it's crucial to understand the aspects of your business that constitute intellectual property, because these are your business assets that can be sold, transferred, licensed, and can identify your business and products and services. So you need to identify which of these assets are essential to achieving your business plans. And then prioritize and cover online IP. Most businesses have limited resources, so it'll probably be necessary to prioritize to make sure you keep ownership and control of intellectual property that generates the most revenue for your business or is likely to have the most exposure. Online intellectual property is going to become increasingly important. So registering domain names, ensuring you have registered your marks, and where you can voluntarily register copyright, which is useful in actions to protect website and online information, is all important. When you're looking to do business with new suppliers in new places, check for your freedom to operate. You should always aim to register your intellectual property, ideally before you start doing business in that location. When you register your intellectual property in those different jurisdictions, always do it in your own business name. Never leave it up to a third party to register on your behalf. Do keep a lookout for infringements in those markets, and where appropriate, include intellectual property ownership clauses in contracts, whether they're employment contracts if you are opening an office in that location, or manufacturing agreements or licensing agreements. And as I mentioned, do secure domain names in those places. The new normal, virtual trade fairs. Online protection is going to be so important, especially of domain names and the like. And for the first time, the Canton Trade Fair, also known as the China Import and Export Fair, has been moved to the cloud since its inception 63 years ago. So this is currently underway. It concludes this week. It has about 50 virtual exhibition areas, and it has promoted the fact that it offers 24-hour online services, including IP protection, as well as finance and other support services to guarantee the interests of foreign trade companies. It'll be interesting to see how effective that is, and I can't yet give you feedback on that, but this is clearly an indication of what the new normal will be for at least the time being. I think we can say what we should expect is that there will be a need whatever happens in the future, to have registered your intellectual property before you can protect it. That is unlikely to have changed. So I've run over, and I apologize for that. I'm just going to really just emphasize one message here as a takeaway, and that is what I've just said, to register. Whatever happens with intellectual property rights and changes in IP laws as a result of the pandemic, it is most likely that you will have to have registered your rights in the place where you need to protect them. So please continue to look at registering your rights wherever you can. So on that note, I better hand quickly back to Nora in case there's time for any questions. Nora, back to you.
Thank you very much, Simon. It was a great presentation. No worries about the time. I think our participants appreciated it, and also it was good to go through the practical aspects and take a kind of positive approach while also highlighting the key challenges in the what are the current trends. So I would like to now encourage our participants that if they have any questions, any concerns, any comments they would like to share with Simon and the help desk, then it's time to send their questions so we can quickly address them. But also if in case for any reason they don't want to ask the questions now, you can always contact us later on via email, and we will come back to all of you with answers. I honestly I've received so far just some comments that thank you very much for the help desk and the speaker for the great presentation. Thank you for the participant. So Simon, let's start with a question which is related to China. That what is basically China doing now about online sellers of counterfeit products, if we want to discuss it on a practical level?
Oh, thank you, Nora. Yes, yeah, interesting question. Actually, China has been taking a number of measures to try and reduce the impact of online sellers. China's new e-commerce law came into effect in January 2019, and so we're beginning to see the impact. Basically, that law specifies the joint liability of the e-commerce platform operators for failing to take necessary measures after they know or should have known that a seller on the platform has infringed any intellectual property rights. So e-commerce platforms now tend to respond in a more timely manner and more effectively to infringement complaints and takedown measures. And that's likely in part for fear of the liability attached. But there's still a couple of issues I need to point out. The first concerns the use of this trend to use copyright registration of trademarks to obtain a valid certificate to start selling counterfeit products online. The problem with this, and certainly in China, this is that it considerably reduces the chances of the true IP owner obtaining a favorable result in such a way that the notice and takedown procedure tends to be efficient only if the claimant has properly registered IP rights in China, and that means both trademark and copyright. And the second issue concerns the dispute procedure. The notice and takedown procedure regulated by the e-commerce law allows bad faith online sellers to provide a statement that they have not committed an offence. So the opportunity of having a defence is not bad per se, but the procedures determine that in cases like that, the platform must end the measures it has taken against the seller, except if the claimant starts an administrative or legal action within 15 days. So the consequence is that the right holders bear the significant costs of these procedures, for which they'll only obtain some compensation much later if the qualification of infringement is retained. But despite these 2 points of concern, I think overall e-commerce platforms are evolving. They're finding new solutions to the problem of counterfeiting, such as the Intellectual Property Expressway launched by Alibaba, which allows all brand right holders who've got a business relationship with Alibaba to make complaints on IP issues on their intellectual property protection platform and get a fast response. So there are developments, they're moving in the right directions, but there are issues to be aware of.
And thank you for clarifying that. And if we come to move to Southeast Asia quickly, and we want to see more directly how counterfeiters are really taking advantage of COVID-19 in Southeast Asia, what kind of examples you would mention?
Yes, well, I think, and we've probably seen in some, most of us have seen in newspaper articles and the like, a fairly common trend is that counterfeiters are taking advantage of COVID-19 to advertise and sell fake face masks and hand sanitizers and other personal protection equipment. I know in Malaysia, for example, there's been a surge in counterfeit product listings online platforms. There have been some false advertisements and claims that counterfeit products are 100% genuine or original. And there have been some extraordinarily low price points, which are pretty much instant red flags. Merchants don't disclose their full details on online platforms and are not easily identifiable. And an ongoing problem is that they adopt brand owners' marketing materials to promote counterfeits as authorized or genuine products. So that's an issue in Malaysia. And across the causeway in Singapore, we've had an Interpol operation called Pangaea 13, which was in March 2020, and that resulted in seizures of nearly 4.5 million units of fake products, including counterfeit and substandard masks, coronavirus sprays and coronavirus packages and medicines, and totally valued at about $14 million. And they've also taken more than 2,000 websites and links off from online sellers advertising items relating to COVID-19. Again, mainly counterfeit surgical masks. And again, the same trend has been spotted, and that's that counterfeiters frequently use manufacturers' advertising or stock photos in their advertisements, but send customers their counterfeit products. The same is true in other countries in Southeast Asia. In the Philippines, personal protection equipment and medical and health devices and pharmaceutical products are currently in high demand. There's demand's going to be sustained in the coming months too, it seems. And the Intellectual Property Office there has reported that there have been complaints filed against sellers of counterfeit equipment and face masks and N95 respirators and such. So I think the trend is that there will be infringers who venture into producing COVID-19 type products and will try to leverage sales using well-known brands and copyright images from the genuine IP owners. So this is clearly something to be cautious about.
Yeah, thank you, Simon. And I think this also leads us again to the conclusion that for all those participants who are not yet doing business in Southeast Asia or China, but they are interested, it's a message to keep in mind, and in order to make sure that they have a soft landing in the market, they should think about IP registration early enough. And if they need any advice for that, contact the help desk. I think with that we will close the Q&A session. I would like to have one comment to the attendees, is that the China and the Southeast Asia Helpdesk has a blog. It's called Your IP Insider, and we publish articles every month on this blog related to China or Southeast Asia, and we actually have already tackled some interesting topics related to COVID-19. For example, the increase in online counterfeit products or the diversification for the supply chain. So this is something that some of you might be interested. So we welcome you to check it out and learn more about these topics. Yeah, so Simon, thank you very much for your presentation once again, also for giving some further information on the questions. So it was well received and appreciated.
Thank you, Nora.
Yeah, and for those who are interested in Myanmar, next Friday we are doing a webinar on Myanmar related to counterfeiting and brand protection during COVID-19. What a surprise in Myanmar. Actually, it's an interesting country as well, because the IP system is not so developed, so it's not easy to get information about the IP landscape of Myanmar, and we will have the chance to have an expert who is based in the country. So if you are interested to do business in Myanmar, we welcome you to join the webinar. It will be a collaboration with the European Chamber of Commerce in Myanmar. So thank you very much for everyone who joined us today. I hope you enjoyed the webinar. Thank you, Simon, for the presentation once again. And I wish good health to everyone and hope to see you at other webinars in the future. Bye.